So we're clearly incented to negotiate and settle.
I think the supervisors hit basically point 3, which is we have very little ability to influence the pace of certiorari's.
No, 0.
And
why can't we file a note of issue at any time?
We can't. That was part of the issue with the legislation. We have to wait for the plaintiff, and that's why we've asked. All we can do is have it dismissed after 4 years if they don't file.
okay, and then the last point, which I think is a very important point, is during this 4-year window during which the town is fairly powerless to do anything to advance resolution, the amounts of the assessments in dispute increase and potential interest charges increase.
Yeah, now this is important. This last point you're going to see in our last slide, and that's where the whole community is put at risk because of the system.
Okay, next slide. The next slide is sort of, I'll describe it as a grading system for, I guess, the town assessor. It's the best way to describe it. It's, again, charted by year. The green bar represents the this represents settlements, actual settlements over time. Okay? The green bar represents the total value of the properties we reached agreement with. The blue bar represents the agreement amounts, the total amount of the assessment we agreed to, and the red bar essentially represents the difference or the amount that the town, school, county, and village were making tax refunds against. As you can see, mostly our assessments are pretty close to the settlement numbers.
Now the most important office in the most important office in the town of Rye, Mr. Abel, we're going to give you a test afterwards and see if you pass. The most important office in the town of Rye is the assessment office. That very clearly is the most important office. And the reduction in these red bars means we're settling at lower and lower values. And we're getting tougher and tougher. So that's part of the whole effort. So kudos to Mr. Markowitz on this particular front.
Just point, at 2009, the red bar is in the vicinity of 1%. It just simply doesn't show on the chart. Okay, just so everybody's clear. Okay. I guess moving on to the next chart.
All right, well, here's the problem, Mr. Noto. This is the problem of the wall of shame scamming the town of Rye. Scamming the town of Rye. So you have a constant buildup. So now we're at $3.7 billion in value at risk. $3.7 billion in value at risk. Because that's the cumulative impact of the court's cases that aren't settled. I think you have a table. Next, where's it?
There's a discussion of what this means in real tax dollars if it were actually...
Perfect. You want to take us through it, Mr. Markowitz?
What we tried to do is look at essentially the exposure of all the jurisdictions within the town. Again, the school districts have the largest exposures, followed by the villages, followed by the county, and the town, who spends all the money to defend these, has a very small percent of the exposure in reality. If you added up, if you assumed, and this is an assumption, and this is not the real world, that every claim by somebody suing us were sustained, there would be $3.7 billion of reductions to assessments. That translates into a refund potential of $75 million spread across every taxing jurisdiction within this town. So it's not a town number, it's not an individual school number, but it's a total potential number. It's the best way to describe it. But I think that the third point, which is if you look at the recent settlements and you say what's the high, what's the low in the real world, if you assume the low is probably a 5% reduction and a high is 20%, a 20% reduction, you can calculate that potentially there's about $3.8 million to $15 million worth of potentials associated or potential refunds associated with all these cumulative certs.
Yeah, but see, Mr. Noto, this is we shouldn't have to be fighting with people. No, just go back. fighting with people, stealing money from our school children. And the $75 million is an attempt to steal $75 million from our school children. It's absolutely egregious that any corporation in the town of Rye would resort to this kind of heinous activity, to steal $75 million in taxes from our kids. And so there's no reason why the town of Rye or the other municipalities should be put at risk in this fashion. If we got the valuation wrong, then just come and tell us. That's the whole reason for the Board of Assessment Review process. If we got the valuation wrong, fine. That's why we spent all this time on a reval. And we'll sit down and discuss it with you. Show us your numbers. If we got it wrong, we'll sit down. But don't play these gimmicks and games and put, 75. We only collect $160 million a year. That's well over, it's basically 50% of the overall town of Rye tax bill for everybody. So the next page. Now, maybe Mr. Noto, you want to come up and help out now and talk about the proposed legislation. We invited State Assemblyman Latimer to come here tonight. Unfortunately, he couldn't make it. But basically what we're trying to do is propose legislation which will dramatically improve our situation. Maybe could you just describe the problem?
Yeah, if I may, just wanted to touch on a couple of the points you made, just so that those who are might be watching on TV and to clarify one issue. On the exposure, the certiorari process is very much stacked against the municipality. And what's very important in terms of the plaintiffs from the plaintiffs' bar, and just so you understand that this has created a cottage industry. I mean, there's an entire bar that dedicates itself to certioraries.
We'll get to the lights on.
And look, they're all outstanding lawyers, and they serve their clients well. The problem with the process, and I know this is a point of great soreness to the supervisor, the 10% of when they come in at 10%, this is a legal strategy that has absolutely no relationship to the actual assessed value, nor does it have any relationship to what the plaintiff really believes is the assessed value. Unfortunately or fortunately, a plaintiff in a cert cannot get an amount less than what they ask for. So any very cautious lawyer is going to come in at the lowest possible number so that they can better serve their client. So if it was going to be reduced substantially, the judge wouldn't say, well, you only asked for 50 and I'm giving you 40. It doesn't work that way. And I understand that it's very annoying because when you look at that chart that shows the potential exposure, it's extremely high. But the reality is, as we know from the settlements, the exposure is a lot less. But that's the system, and the system isn't working for the municipalities.
But the problem with the system, when they come in at 10% of value, they make the Board of Assessment Review process a nonsense.
Absolutely. And
when they do that, then as soon as they file the cert, then you have the knife hanging over your head for 4 years.
Right. Which is
then
why
you have to go hire a lawyer to defend the court. You have to go hire an appraiser, and you completely. There's no how many. We haven't. I think it's rare that we actually go to court because basically the system is the cards are so stacked against us.
I will describe it as the last thing either side wishes to do is actually have a trial.
But given the fact that we're working very hard to get our valuations correct, and with our new reval effort this year, physical inspections of every one of the commercial properties, I'm not going to be settling any of these things. I'm going to take everyone to court because our valuations are right.
Right. I think that what we've done last year, when we identified some of these issues, we went to ORPS, we spoke to their legal counsel, we drafted a bill with their assistance that did these three things, that we provided the town, a town that did reval or any town had the opportunity to demand a note of issue be filed within 6 months of the commencement of an action. Now, keeping in mind, when you talk to other communities, they don't want this because most communities want to delay the inevitable. So the communities had a built-in incentive not to accelerate the resolution of these certs, because invariably, more often than not, the community ends up paying money. So understand there is not a great movement amongst municipalities to say, hey, let's accelerate these and find out how much we're going to pay. On the contrary, their view of it is that we're going to kick the can down the road. We're going to let it go 4 years and deal with it then. And so we are very unique in that you are probably, if not the only, one of the very, very few supervisors in the state of New York who would be advocating accelerating certs. And part of it, and I think we are correct in that it gives you predictability in terms of budgeting. And the town, by the way, has virtually no exposure. I mean, really, we're doing this for the villages and the school districts. And I think they have the right to know what their exposure is. And we've met with Portchester, who've reached out to us to get a handle on what their exposure is this year. And if others wanted to do that, we do that with them as well. But the state law, which we did get Oppenheimer and Latimer to introduce in both of their respective chambers, would have given us that standing. We asked that for a local community like ours that have an income and expense law, that provide a sufficient basis to dismiss a cert if they did not provide that information. And thirdly, it would provide us with the same level of protection that non-reval communities get on freezing a settlement for 3 years. The state Senate adopted the law and passed it. The Assembly did not. As you know, we also had conversations with the chair of the Real Property Committee in the State Assembly, Sandra Galiff, and members of her staff. Candidly, they were very unhelpful, I thought, in their approach to this. They were clearly not sympathetic to the municipality. And Assemblyman Latimer has promised that since it did get sidetracked, they're having a lame duck session starting on the 29th of this month. He said he would ask that it be adopted as the Senate bill was, so that it would become law and go to the governor for signature. If he does not do that, if he's not successful, in January we would have to start from scratch, de novo essentially, and refile the bills again and go through this process for this session that starts on January 3rd of next year. So there is another thought here, and really I'm just thinking out loud. Those of you that read the New York Times and the New York Times Magazine, there was a very interesting article a couple of weeks ago about the BP spill in the Gulf. And, as you know, everybody hates lawyers. And a part of the article was the fact that BP and other companies were essentially bypassing the plaintiff's bar because the lawyers are, all horrible people and they're all making millions at the expense of other people suffering, and basically going right to the phase, the damages phase, and trying to work out with these people a fair settlement without going to trial, without having the expense and having the lawyers, take a big chunk of the proceeds. And it was a very interesting article, and it was a very interesting approach. And I'm not sure how it would apply here, but I suspect that reval, the whole point of reval, is our assessed value is within a few percentage points of 100%. That's the whole point. It is supposed to reduce certiorari claims. And at some point, there might be an effort of an outreach, because the same 100, 150 properties file every year. I mean, we're not getting new people filing cert claims. This is the same properties year in and year out, with the same lawyers or the same representatives. So, I mean, Mitchell probably knows these people better than people who work here in the building. And there's an ongoing relationship, and I'm thinking at some point, maybe, because they're represented by counsel, I couldn't do this. But if the assessor reached out to the home property owner and said, look, you keep filing these claims, why don't we sit down? These are the numbers. Why are you bothering to do this when, in fact, you can see? Now, we've had some success with sale data, which we have presented to the council, and 8 cases were withdrawn this year based on the fact that the properties were sold. It's public information. The sale data was consistent with our appraisal, and they did the right thing and withdrew the claim. So at some point, to either make the bar process more meaningful, to try and do an outreach to some of these property owners and say, you've been filing every year for the last 15 years. neither of us are getting anywhere. We're chasing our tail. These are the numbers. If you think it's different, let's talk about it. But maybe we can resolve it at this level and make the bar a little more meaningful. Because the bar, as you pointed out, is simply a formality. They file it because they have to file it in order to get to the next step, which is the cert claim. And